Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I would like to talk about the notice to appear. What is the notice to appear, you ask? Well, this is this is a particular document that essentially begins the deportation and removal process if you happen to be inside the U.S. So it is a very important document that you have to be aware of because if it is served on you, then essentially jurisdiction of you will rise over the immigration court, and the immigration court ultimately will have the power to deport you or to not deport you. So if you're just working someday and ICE comes and detains you, hands you the notice to appear, and you sign it, actually even if you don't sign it, if it's proven that it's given to you or it's properly sent to you, it will most likely have a date on it that you have to be in court at a certain time and place, and if you do not, then the court will order you deported in absentia, and then immigration legally can enforce that deportation order and remove you forcibly from the country. So the notice to appear is not a document that you want to ignore. Okay, so I want to get into this a little bit because, I have many other videos on different areas of deportation, but sometimes people ask, well, how do I end up getting into immigration court, and then, can I can I fight excuse me, can I fight this notice to appear? Well, the answer, first of all, is let me just walk you through a typical scenario of how the notice to appear is issued. Okay, sometimes you'll be at the wrong place at the wrong time, and ICE will be doing a raid on an apartment or work, and of course they'll ask for IDs for everybody, and boom, you get caught in there. You don't have any identification, so the next thing you know is they hand you the notice to appear. They have you read it, sign it, and then it of course lists the time that you have to go to court. Now you're in removal proceedings, with the exception that after they serve you, they being ICE, they are required to then send and serve the immigration court with the notice to appear, because the mere fact that they just send it to you or they give it to you, that by itself doesn't immediately put you into removal proceedings. In fact, only when the immigration court gets it and then the immigration court system generates a notice of when exactly it will be, are you in removal proceedings. 99.99% of the time when you first get the notice to appear, it will state that you have to be at court at a certain time, certain place, but it doesn't specifically list it. It'll say basically to be sent. And usually after you get it, within 2 to 3 weeks, you will be able to get the notification from the court as to when you have to go to court. Okay? Now, as far as other ways that the notice to appear are issued, many times if you have committed a crime and you're finishing up your sentence, you will get a visit from an ICE official, and the ICE official usually, and this is from 20 years of doing this, what they tell me, they'll come and they'll tell you, you have no chance of success. You're going to be in detention for 20 years. Look around you at all the people in there not winning. It doesn't matter who tells you what, you're not going to win. So just sign the paper and you'll be on your merry way. Except what you're signing is a voluntary deportation, and you're giving them the right to forcibly remove you from the United States without lifting a finger. Okay? So the best thing you can do when an ICE official comes in and gives you the little speech is say, thanks, but no thanks, I want to go in front of an immigration judge. And just leave it at that. No matter what they say, I mean, you can be respectful and you can be nice, but you do not have to sign the voluntary deportation paper. And believe me, it is ICE's job to try to remove you from the United States. They want to make it easy on themselves. So for them to say what they say, and I'm not saying 100% of them do, but I've heard it enough that I know this is what goes on. From them to say what they say without being a lawyer, without knowing what you do or don't qualify for in immigration court, without knowing your exact situation, is really a little bit questionable as to, how and why they do that, which gives you the benefit that you need to fight your case. Okay, if it turns out in the future that you don't win, or that after a while you just don't want to stay in detention anymore, then you can always sign or withdraw any application that you have at a later time. But you should get an immigration attorney to analyze your case to see what you qualify for. Many times you might even qualify for bond, so you might be able to fight your case while being free. Okay, and believe me, an ICE official has no idea about what it would or wouldn't take in order to do that. So make sure, if you're a family member watching this and you have somebody in detention, make sure they don't sign a thing. Okay, and then try to fight your case. And if you do fight it and win, that's great. I can tell you that while it is possible to fight cases on different grounds after you've been deported, and there's all kinds of ways that I help people doing that, the fact is that it is easier to fight it while inside the United States. Okay, that's a fact. So that's another way that the notice to appear would be issued. So once you don't sign, essentially, the please deport me paper, then they will issue the notice to appear, serve it on the court. The court will come in and you'll be transferred to immigration detention, at which point what my firm would do, we would do a bond redetermination hearing in order to see if you qualify for bond. We have a lot of people in the coffee shop today, so hopefully you can still hear me even with all the background noise. But continuing, when you get the notice to appear, let me just tell you that the particular avenue that you're going to want to take when you go into immigration court is not just to admit everything on there. Okay, assuming you have a qualified immigration attorney, you have to fight the notice to appear. Sometimes what they will do is they will list, for example, a crime with a wrong date, a crime with a different name, a crime with incorrect court, whatever it is. It's my practice never to admit that you committed a crime. Okay, it is their burden, meaning immigration's burden, to show by clear and convincing evidence that in fact you committed the crime. And it is only after that they have sufficiently proven by clear and convincing evidence that you are able to move forward, and essentially the judge then will find out what relief you may or may not qualify. But if they don't meet the initial burden that you are removable and that you, for example, have committed those crimes, then the case can be terminated and you will be able to move on from there, hopefully without the removal proceedings. So I've had cases, in fact, where the immigration did not have the documents necessary in order to show that the crime was committed. They just put the allegation, and then the judge turns to my client and says, "Did you commit the crime?" Well, of course, I immediately object, and I say, "Look, Your Honor, the burden of proof is on the immigration service, not on my client to prove the crime was committed. And you can't alter this burden by asking the client if the crime was committed." And then, of course, sometimes the judge will proceed forward and say, "Well, did you commit the crime?" And I'll object based upon the Fifth Amendment, right against self-incrimination. And of course, the judge will say this isn't a criminal proceeding and so forth, and it goes on and on a bit, but in the end, the client doesn't admit it. Okay, the particular avenue of trying to switch and alter the burden cannot be done by the immigration judge. So that's one thing on the notice to appear. As far as the pleading stage of what to admit and deny, of course, there are some things that have no reasonable ground to deny. For example, if it says that you're not a U.S. citizen and you were born in whatever country, if that's the case, then that has to be admitted. But even then, with citizenship, there might be derivative citizenship issues where you might not know that you're a U.S. citizen. Regarding dates that you entered the U.S., sometimes by 1 or 2 months there's a difference of eligibility for cancellation of removal. So of course it has to be determined with accuracy when you may or may not have entered the U.S. and how you entered. As far as the grounds of removability, sometimes they'll have 3 or 4 provisions of law showing why you're removable. Sometimes I'll admit 1 or 2, and then the others I'll deny. Sometimes you have to fight the removal, the charge, for example, as an aggravated felon. As far as the service of the notice to appear, sometimes the service is not proper, and we can have it thrown out. So there's all kinds of ways of fighting the notice to appear and doing it properly. The initial hearing at immigration court is called the pleadings stage, and in this particular hearing, it is absolutely necessary that you have an expert immigration attorney who knows what they're doing, because sometimes you will get an immigration attorney or an attorney who will just admit everything and then go on and apply for something. And that's, in my opinion, a grave error, because first of all, you don't know if the judge is going to approve everything or anything. You have to fight what legally you can fight from the beginning, and you have to make every effort in order to go forward to protect, of course, you, the client. And sometimes the pleading stage is only, for example, 10 minutes long, but it's a very important 10 minutes because it does direct the path of how the hearings will go. Okay, so I have just given a little bit of issues and so forth that occur with the notice to appear, and I'll have more as time goes on, more different videos. If you like this, go ahead and click like and subscribe. I usually do 1 or 2 videos a week, and then we'll go from there. More on the coming videos.